Good morning, everybody. My name is Margaret Hinkle. Welcome to our meeting today. Let me call this meeting to order and begin by recognizing those commissioners who are present. Let me ask for a roll call vote. Commissioner Bluestone,
Good morning, I'm present.
Commissioner Calderon. Larry, you're muted. He's present. Commissioner Chrisman,
Good morning, I'm present.
Commissioner Hall,
Good morning, present.
Commissioner Kesrosian,
Good morning, present.
Commissioner Luma,
Good morning, present.
Commissioner Talley.
Morning, present.
We have a quorum, and the only commissioner who is missing today is Commissioner Baker. I think with that, we will move to, I would entertain a motion to approve the minutes of our October 16th, 2025 meeting. Is there such a motion?
So moved.
Is there a second?
Second.
Thank you. Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Crispin,
Yes.
Commissioner Hall,
Yes.
Commissioner Kesrosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley.
Yes.
And I also approve it. Those minutes are unanimously approved. Let me turn now to item number 3 on our agenda, our Executive Director report. Enrique, you're up, please.
Thank you, Madam Chair, and good morning, Commissioners. I do not have a presentation today. I will be speaking instead about a few of the materials that were included as part of my report and giving you a general update like I normally do. I will start with my summary of the outreach and presentation efforts that myself and other members of POST have made since the last commission meeting. On October 24th, General Counsel Ravitz was a panelist at the Boston University Law School program on state government and policy work. At the program, Comptroller William McNamara and attorneys from 7 agencies spoke about the missions of their offices, the challenges they face, and it was a good opportunity to interface with law students and new lawyers. On October 29, I attended the Mass Police Accreditation Commission Awards ceremony. Police departments that choose to participate in the MPAC program go through a rigorous evaluation by assessors and eventually get certified or accredited. At the event, 21 agencies were recognized for their efforts. And it was interesting to see that throughout the event, there's an opportunity for every chief to come in and provide some remarks. And a clear narrative emerges out of those testimonials. And that is, there's a lot of work and dedication and pride associated with the effort of being certified or accredited by MPAC. As we continue the efforts to draft standards for agency certification, understanding those efforts, in my opinion, is key for us to ensure that there's no duplication of efforts and an ongoing accreditation. On November 6th, Counsel Jerry Cahill represented POST at the Boston University School of Law Government Employer Fair. It took place at the BU Law campus, where Jerry was able to share with law students information about the commission and the work we do. Like in the past, this presents a good opportunity to discuss the commission and get students eager to know about opportunities that may arise within POST. They also attended a virtual meeting with POST directors of the Northeast states of IADLES, the International Association of Directors of Law Enforcement Standards and Training. This was a virtual event. The region includes states, from Pennsylvania and Maryland all the way to New England. These roundtables are typically very useful to directors as we learn about current and emerging challenges, as well as best practices for organizations like us, other POSTs. I'll move on to a different topic of my general update, and I will mention that at the end of October, we received a letter from Worksman, Jackson, and Quinn submitting a complaint about Boston Police Commissioner Cox. We are replying to this letter. We haven't done so, but we'll do so today or tomorrow, but essentially stating that currently Commissioner Cox is not certified. It has been the position of the city of Boston that he is a civilian, does not perform police duties, does not carry police powers. Commissioners might remember that recent conversations in the context of elected sheriffs, that certain administrative heads of agencies may or may not come within the scope of post, depending on their situation, whether they are operating in an administrative capacity or whether they also carry police powers. At a meeting earlier this year, we brought an update and attempted to further define the term head of agency, which is a term of the statute. And we expect to come back to the Commission with additional details for the construction of scope for civilian oversight of agencies. Commissioner Cox is not necessarily the only individual that this applies to. And the circumstances when those individuals, elected or appointed, must be certified by post. I will move on to the second topic listed on the agenda as part of my report. And I will mention that we received a letter from MACOPA, the Mass Chiefs of Police Association. They are requesting that the Commission consider the formation of an advisory committee. That letter has been included in the packet, and I have also included a memorandum that is responsive to that request, but recommends additional parameters for forming such a group. Let me summarize briefly the memo and the letter. The Chiefs Association requests the formation of an advisory committee comprised of chiefs to advise the Commission in the early stages of policy formulation. I think an advisory committee is a very good idea, but I would like to suggest that it not only be comprised of chiefs, but include other stakeholders. This could include some of the organizations that have in the past provided comments to us or might be interested in the future in providing comments to post. As I explained in the memo, a diversity of backgrounds is typically a very good component of an advisory committee like the one envisioned. In addition, I would recommend that the Commission consider the formation of the group, and in doing so, that the group would also be considered a subcommittee for purposes of the open meeting law, a subcommittee of the Commission for the purposes of the open meeting law. This brings additional benefits, including the opportunity to have public participation and feedback from a larger group, not just the advisory committee. This brings additional resources required, but we've done that in the past with the subcommittee and certification. In addition to the applicability of the open meeting law, I recommend, as I just said, that the committee be conceived as an advisory role only. In other words, no delegation of any specific powers that rest within the Commission. This could also include a manageable number of individuals or their designees, so that that committee can have can meet quorum without too much difficulty and have, as I mentioned, a diversity of backgrounds and perspectives. In the memo, I described the reasons for those recommendations, and I think, as I mentioned before, it's a good idea. It's something that we recommend that the Commission consider. If the Commission agrees with this request and the parameters that I propose, staff can come back to the Commission at a future meeting and with specific recommendations of those members and take it from there. So let me pause here to see if commissioners have questions or comments on anything that I have mentioned up to now. I see Commissioner Luma.
Yeah, just a question. I saw that they requested a meeting. Did that happen already, or the discussion happen already with them?
No, in their letter they requested, they suggested 2 days to have a meeting. One has passed and one is in the future. I responded saying that as per their request, I would put this matter in the agenda like I just did, and suggested that we pencil in the second date, which happens to be next Tuesday, to have such a meeting and understand more of what they say or are thinking about, maybe the number of people or composition or whatnot. So we have not had that meeting.
Thank you.
Are there any other, yes, Commissioner Calderon, please.
Thank you, Madam Chair. Executive Director, the meeting Tuesday, is that a meeting of the commission that's going to meet with the Chiefs Association, or who is this meeting with? That'd be, I guess, my first question. And then I had some questions about the overall idea.
Yeah, so it's envisioned to be the staff. They wanted a meeting with me and some staff to discuss this proposal. Because of what I was just recommending, the parameters that I suggested, that it be a group that the commission forms. We did not meet yet. I wanted to first make sure that you were briefed and you were at least on board with the general idea, or there were no major objections, in order to then have the meeting. So the meeting would not be a public meeting with the commission. We have not envisioned. We had it envisioned to be a meeting with me and other key staff, a few of their members, maybe those that signed on the letter. They call themselves the executive board of the Mass Chiefs, and we would then, take it from there.
Okay. Well, I guess thank you for answering. I don't know about my colleagues on the board, but I think that the representatives from the Chiefs Association, that conversation should happen here with the commission in a public setting. The reason that I say that, even though I'm a police officer myself, we want all input from all stakeholders, and I think the process that we've been utilizing since our inception has worked rather well. We've had all stakeholders have an opportunity to come in and testify, whether it's in the public meeting in person that we've had or submitted letters of recommendation and input. I'd be cautious about a special advisory committee made up of special people. It sounds to me like, even though the idea is valuable and probably well thought out, it gives the impression that an advisory group made up of hand-selected people or hand-selected representatives would have, for lack of a better term, inside knowledge or the ability to consult with staff as opposed to consulting here with the commission in a public setting. So, I mean, I think an advisory group made up of hand-selected people probably gives the wrong impression. The way we've been running our process by allowing anybody to come in, chiefs, various groups that I know that I've been present for, has been working rather well. So I'm taking a cautious approach to it.
Go ahead. I'm
Can I
sorry.
just, make a point, a couple of points, if I may, Commissioner Calderon. One aspect to that I think is responsive to what you bring up is to make this advisory committee subject to the open meeting, so that then the input can be all done, in the open meeting. I don't know if I was very explicit in my memo, but let me highlight that we could put it out there and ask for intention, or let people to identify themselves, organizations to identify themselves as to who might want to be part of that committee. In other words, we could solicit, interest, and like we have done in the past, and from those individuals or organizations that identify themselves, we can then, at your discretion, recommend, you can accept, and you can modify those who may be part of that advisory committee or not. The trick part, and you also alluded to this, Commissioner, is going to be to try to keep the advisory committee small enough so that we're able to meet quorum. Because as my experience has been, that when these committees become too large, it's hard to just make a meeting that works. So that by definition limits, as you alluded to, the number of people that might be in a position to participate. But that frankly is a trade-off that we need to think about.
I appreciate it, Mr. ED. And again, with all due respect to my chiefs and my fellow brothers and sisters in law enforcement, I understand that everybody wants to have a voice, and again, it's probably well intended, but I just think it gives the wrong impression to the general public. The spirit of what we do is so that chiefs, unions, rank and file don't have I always look for better terms, but I guess inside baseball, we'll call it, but to have a bigger voice than anybody else. I don't know that I'm in favor of giving that impression. The process that we have now that allows chiefs, the NPTC, union officials, civilians to come in and testify before the commission openly, or submitting letters that we then read openly, to continue with the full transparency that I know that we've been exuding since our inception. I'm kind of in favor of that, but I'll keep an open mind to it.
Thank you. Commissioner Talley, please.
Thank you. Director Enrique, this is just more of curiosity. The meeting that you attended with other agencies and et cetera, are they a governing body or just a resource? Governing body meeting, do they come up with recommendations of things that we should be doing or process procedures, that kind of stuff?
Yeah, they're organizations much like us. They're either an independent agency or an agency within a larger agency, for example, the Attorney General's office in some cases, that they're public agencies, in other words. They have, there will soon be a post in every state. Hawaii is coming online, as I understand, this year. IADLES is this organization that brings all of those organizations together. They put a conference once a year, and there's, because of the benefit of that conference, and which has been mostly around sharing best practices and the roundtables that we participate in. There was this decision to create also sub meetings, the one that I just mentioned, regional meetings. Just understanding what the differences of approaches and the similarities of challenges proves to be very valuable. And that's why I figured I mentioned it here. This was a virtual meeting, but there will be opportunities for some in-person meetings in the future, like the annual meeting.
Yeah, thank you.
Commissioner Bluestone.
Yes, thank you. I similarly to Commissioner Calderon share some of the concerns about an advisory committee that is composed primarily of leadership. I am in support of this idea. I think that we do need input, especially from chiefs earlier in the process, when we're developing procedures and regulations that have significant practical implications. And sometimes, we may not be aware of how that might impact departments in real time. But for me, my suggestion would be that we consider recommending that advisory committee, if it goes forward, also include a line of duty officer. I also think that a records clerk or a records supervisor would be a person who should be included in that committee, as well as outside stakeholders. And of course, I would recommend that there be a person with a mental health or trauma background.
Thank you, Commissioner. We can make sure we can solicit feedback if the rest of the commissioners agree with a similar approach, to see who among those who follow us and who have engaged with us in the past might be interested in participating, and we can bring a list of positions to you at a future meeting.
Thank you, Enrique. Do any of the other commissioners have any questions or comments at this point? Enrique, I do have a recollection that the issue of an advisory committee very early on was raised by the Strategies for a Youth group. I think whoever was part of those who were original commissioners may recall this, and at that point, we simply decided that we would not go forward with an advisory committee. I mean, this went back several years, but I do have that recollection. And I see Commissioner Calderon is affirmatively shaking his head on that one. So I think at this point, then, the question is, go ahead, Commissioner Calderon.
I was gonna bring it up, Madam Chair, but continue on is, yes, I was shaking my head. That was a group that I believe, I had met with before the formulation of this commission. And I believe I brought them to our public meeting, and we decided that we weren't gonna do an advisory committee, but, continue, please, and I'll wait, because it sounds like you're saying the same thing.
And I think, since I don't see any other commissioners at this point with questions or comments, Enrique, what is your suggestion as to next step with regard to this?
Well, my recommendation, as I mentioned, is that that we consider the formation of such a committee with the parameters that I outlined in the memo, not exclusive to leadership, open, subject to the open meeting law. We could solicit interest from everyone that is on our mailing list to see who might be interested in participating if the commission is not opposed to this idea. And again, we can bring you back. We could have that meeting that the letter alludes to, see what they were thinking. If I read the original letter literally, they seem to be suggesting that the committee be just one of chiefs, and that's one of the reasons why I add the parameters that I just explained. Which would be, responsive to their request, but with the condition that others be involved, which is the main concern that has been brought up. So again, we can, unless there's major opposition by the commissioners, I recommend that we could just elicit some interest from people and see who would like to participate. I know there's questions out there, but as an alternative to all of this, because it's a formation of a subcommittee of the commission, there could be any number of commissioners interested in participating. If time allows and they would be interested, that could be another subcommittee of the commission.
Commissioner Bluestone?
I guess I just want to express my support for the idea of a primarily law enforcement based advisory committee rather than a more broadly based diverse committee. I think that we already have diverse groups giving input to our policy decisions and lots of opportunity for people to review anything that's promulgated. And what I hear in this request is that law enforcement is asking for more input at an earlier stage in our policy process. And that seems appropriate to me. I would be concerned about creating a committee that can't reach a consensus around particular issues because it's too diverse. And so I'm in favor of supporting law enforcement in that sort of opportunity, less supportive of the idea of an advisory committee that is more diverse.
Commissioner Luma?
Yeah, I just want us to be thoughtful around this. Because I imagine if we do create this advisory committee, there are going to be other stakeholders who also want advisory committees. I think about the public perspective, people who are interacting daily with police officers and want to provide input in that way as well. So I just want to make sure that we're thoughtful and considerate about the other stakeholders who may be, if we do this, it's what are we opening the door to, and what's the intention and purpose behind it? Like Larry was saying earlier, we have a forum for that already. And so I just want to make sure that we're responsive, but there's thoughtfulness behind it, and we consider other stakeholders who may want the same access.
Commissioner Calderon?
Thank you, Madam Chair. I agree with both my commissioners, Commissioner Bluestone, of course, I'm all in favor of law enforcement input, whether it be the chiefs, the rank and file, and the members I represent. But my point is that we already have that. That's why I'm more strongly siding with Commissioner Loomer about the transparency factor and how it looks. The MPTC by statute is a 15-member board made up of chiefs that already help promulgate the regulations and policies that we put forward here. So in essence, we already have 15 chiefs that have a very strong voice in what we do here. And I know that in all of the open meetings that I was the chair on the subgroup with yourself, Commissioner Loomer, and Commissioner Kazarosian, that we had chiefs, MPTC officials, and union officials, along with a couple of public groups that did come in person and testify, and I believe a couple online. I just think an advisory group is a bad look. We have lots of opportunity for both my membership to weigh in, rank and file memberships, along with the chiefs. And like I said, the MPTC is 15 chiefs already. So yeah, I revert back to, I know what the chair had beat me to saying, but I had brought this up early on in our existence, and the board at the commission that time decided against an advisory committee. So I failed to see how this commission would now turn around and vote for an advisory committee when we already said no, but I'll rest it there. I appreciate the time.
Commissioner Bluestone, again, I think you've got your hand in the air.
I just want to quickly respond to that. I think what's different in this request, at least as I hear it, is that we are now in a stage where we are rapidly developing policies, audit procedures, and these are policies that have significant implications, practical implications for the workload that I think chiefs and other law enforcement personnel are going to experience. And so, as I understand it, they're asking for an advisory committee to give us input at an earlier stage in the process, and to sort of have more of a voice in what actually comes forward for discussion, and the format in which it comes forward. So to me, that seems reasonable. It's an advisory committee. They would not have any authority, in terms of independent decision-making or votes. But I think it could be helpful. So I'm in favor of it.
Any other comments or questions from commissioners? Does any commissioner at this point, given the issues that have been raised by Enrique and the comments of the other commissioners, does any commissioner at this point want to make a motion, or should we simply leave it to our staff to give further thought to this and maybe present it again at another meeting? Enrique, what's your preference on that?
Well, I was frankly hoping that there would be no objections or no major concerns for us to explore coming back to you with a more solid proposal. Obviously, from the discussion, there appears to be, at least a bit of a split take. So if there could be, either a vote or additional comments, I'm happy to to take that. As an alternative, we could have that meeting, understand that that's in their letter, understand, more of what they're thinking, and come back at a future meeting, hopefully the December one, with additional thoughts to either flesh it out a little bit more, or also elicit who might be interested in participating, and get a gauge from that standpoint.
Thank you, Enrique. Commissioner Luma?
Yeah, my recommendation would be to have the meeting with them to learn more about what their request is, move forward with some of the recommendations you made, and see what their response is. I think we just got one letter. I want to know more about their intention, their purpose, and their reasoning behind it. And I think we can better make an informed decision once that meeting occurs, and would love to hear about that meeting and its outcome in December.
Commissioner Calderon, sorry, Commissioner Calderon, please.
Yeah, similar. I think that a motion at this time would be inappropriate, only because in the agenda, this was part of the general update. There was no mention about a vote or a formulation of. It was a recommendation from the ED for its first presentation to the commission. Again, I'm all in favor for whatever makes the commission and our organization run better, but there's a lot more to learn about it. I'm concerned from the onset where law enforcement in general was very involved in the formulation of the statute and the post-commission itself at the legislative level. And there was major concern at that time of over input by whether it be rank and file or Chiefs Association. So I'd like to learn a lot more. And if we go that way, maybe where the MPTC already has 15 chiefs, maybe the advisory committee is made up of outside entities instead of law enforcement. There's a lot of things to consider here, but a motion I think would be preemptive.
Thank you. Commissioner Crispin.
Yeah, so like Larry, I'm concerned about providing access to this group. I think there are a number of constituency groups who are very interested in what we do, would like to have some input. I think if we allow them to have access and create this group and be an advisory group to us, I think we will then be subject to having to listen to other groups who want to be served in an advisory capacity. So I think it doesn't hurt to hear what they have to say, but I think at this point, I am concerned about just providing access to these chiefs as an advisory group to us.
Thanks to all the commissioners for their questions and comments. I think the general sense is, Enrique, you go forward and then we will take this up again. No vote today, but we'll take this up again after you have a meeting and everybody reflects on the issues that have been raised today. So I think we can, at that point, end this discussion unless anybody feels there's anything else that should be addressed at this time. Enrique, are you comfortable with that?
Absolutely. Whatever's your pleasure.
All right, thank you. And I think with that, then we move on to item number 3C, a request for relinquishment of certification. And I think with that, is it? It's
Heather. I can turn it over to Heather Hall, our Deputy Director of Certification, because she's going to take that topic.
Thank you.
Thank you. Good morning, Chair and Commissioners. We have an application for relinquishment of certification from Kevin Dorr for your consideration today. In accordance with the Commission's policy on voluntary relinquishment of certification, the Commission staff evaluated Mr. Dorr's application and conducted the requisite background check. As for Mr. Dorr's law enforcement background, he began serving as a member of the Haverhill Police Department in 1986. He retired in good standing as a lieutenant from the Haverhill PD on July 25th, 2016, and was rehired by them as a special state police officer with a part-time status the following day. Regarding his certification status, Mr. Dorr was automatically certified as a law enforcement officer as of July 1, 2021. The Commission recertified him for a period of 3 years in 2022 and again in July of 2025. The 2025 application for recertification that was submitted by the Haverhill PD stated that Mr. Dorr was performing details only. His certification is set to expire in 2028. He is seeking relinquishment of his certification because he wishes to obtain a private investigator's license. So consistent with the Commission's policy on relinquishment, the Certification Division reviewed the application and internal records did not identify any areas of concern. In addition, the Standards Division reviewed the application and reported that it conducted its due diligence review in accordance with the policy. And that review included a review of internal records, the National Decertification Index, the Board of Probation record, and federal and Massachusetts court records. After completing its review, the Standards Division reported that it did not identify any issues of concern. So in addition to the above review, pursuant to sections 3A, 3 and 4 of the relinquishment policy, Mr. Dorr's application has been posted on the Commission's website through the announcement regarding today's public meeting, so that his law enforcement employer and members of the public could submit comments. I did check in with Jamie on this, and we actually have not received any comments on this application. So based on the staff review, the executive director recommends that the commission vote to grant the application without any additional terms or conditions. And with that, I'm available to answer any questions that you all may have. Thank you.
Thank you, Attorney Hall, for your very good presentation of this request. Do any commissioners have any questions or comments? So I think with that, then, Attorney Hall, you're simply asking for a vote from us. Is that correct?
Yes, that's correct, Chair.
All right. Commissioner Bluestone, yes or no?
Yes.
Commissioner Calderon,
Yes.
Commissioner Crispin,
Yes.
sorry, did you say Commissioner Crispin?
Yes.
Thank you. Commissioner Hall?
Yes.
Commissioner Kazarosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley,
Yes.
and I am also a yes, so that is unanimously carried. Thank you very much. Moving on to the legal update. At this point, we are not going to address the issues that were raised by Attorney Cahill. We will do that at the December meeting, so I will turn, and that was the request to remove the complaint from the public database. We will address that at our December meeting. So I will move on now to item number 5 on the agenda, which is the agency certification standards. May I turn, please, to our general counsel and to Attorney Lee on this?
Thank you, Madam Chair. I will turn the floor over to Attorney Lee, who will discuss the continuing agency certification initiative.
Thank you, and good morning, Madam Chair and Commissioners. Let me just start sharing my screen with a presentation. So today I will be presenting 3 agency certification standards for your consideration. The first standard relates to criminal investigation procedures. I will be presenting one minor revision to this standard, and pending any final questions or feedback, I anticipate asking for your preliminary approval of this standard. The second standard relates to juvenile operations. I will be presenting a first round of revisions to this standard. I will not be asking for your preliminary approval, just any further feedback or reactions you may have. And then lastly, I will be presenting collection and preservation of evidence. This is the first time that this standard will come before you. So again, I will not be asking for your preliminary approval, just your initial reactions and feedback. And so our first standard today, as I mentioned, is criminal investigation procedures. A copy of the standard is available in your packet starting at page 65. This standard was last before the Commission in September when a set of revisions was presented for your consideration. The MPTC reviewed those revisions during its October meeting and indicated it was satisfied and had no further feedback. However, the Commission, after its September meeting, received a public comment from Strategies for Youth concerning the Juvenile Operations standard, which I'll discuss later. But within that public comment on juvenile operations, there was a comment that we here felt warranted just one minor revision. And that revision, as you'll see, concerns youths and specifically the custodial interrogations of youths. And when I say minor revision, here what we're doing is the revision is to encourage officers to record by both video and audio means all custodial interrogations of youths. And this is meant to promote accountability and compliance with the other requirements and prohibitions in the standard concerning the custodial interrogation of youths. And so the reason here we do encourage is we recognize that there's not a pre-existing requirement to video and audio record all custodial interrogations, though the SJC has articulated a preference for recording interrogations. And so we thought that this sort of nicely or succinctly kind of captured that preference while working within sort of existing resources that agencies may have. And so with that, I will briefly stop sharing my screen. And so as I mentioned, the revision that I just presented here is pretty limited, and as I previously said, MPTC indicated it was satisfied with the prior revisions that were before you last time that they reviewed just this past month, and they had no further feedback. So at this time, I'm asking that the commission provide its preliminary approval of the draft criminal investigation procedure standard as discussed and presented today. But of course, I'm happy to take any questions or reactions.
Commissioner Bluestone?
Thank you, Attorney Lee. I'm actually just wondering if you could refresh my memory about the definition of a youth in Massachusetts.
Let me just pull up a copy here. So I believe, as we say for youth for purposes of juvenile interrogations, or not juvenile interrogations, just for agency certification standards as a whole, that it means any individual who's under the age of 18.
Thank you.
Mm-hmm.
Any other questions? I don't think I see any hands in the air, so then let me just take a vote on preliminary approval. Commissioner Bluestone?
Yes.
Commissioner Calderon?
Yes.
Commissioner Crispin?
Yes.
Commissioner Hall?
Yes.
Commissioner Krasrosian?
Yes.
Commissioner Luma?
Yes.
Commissioner Talley?
Yes.
And I'm also a yes, so that is unanimously approved. Thank you very much, Attorney Lee.
Thank you. And I'll begin sharing my screen for our next standard, which, as I mentioned, is juvenile operations. A copy of this draft is in your packet starting at page 80. And unlike criminal investigations, this is just for a first round of revision. So no ask for preliminary approval today, just further feedbacks and reactions. And so to review a little bit of our process here, juvenile operations was last before the commission in June when it was presented for your initial feedback and reactions. As you'll recall, juvenile operations was developed with the assistance of one of our legal fellows, Kimberly Shafford. Following the commission's meeting and Kim's presentation in June, we sought the feedback of MPTC and its staff. The MPTC provided its feedback during its August meeting. Following the commission's June meeting, we also received public comments and feedback, including from the Massachusetts Chief of Police Association, Strategies for Youth, as well as the Chief Justice of the Juvenile Court. So the revisions I will review shortly reflect feedback and suggestions from those parties as well as commission staff. Those revisions relate to the elements of juvenile operations that are on your screen in yellow. I'll note that some of these elements are actually new to this draft, and so they were not a part of the initial presentation that was provided in June. Those elements are on your screen now in green. And so, apologies. I'll review these in order now. So the first revised element to this standard is officer conduct. We have two proposed revisions here. The first revision is to direct officers when engaging with a youth to act in accordance with the agency's officer response procedures policy, and specifically the sub-policy or provision concerning interactions with vulnerable persons. This revision is based on a comment that was provided by Strategies for Youth. They suggested that the juvenile operations standard should explicitly state that youth with disabilities are vulnerable people, and therefore officers should respond to a youth with a disability as they would a vulnerable person. However, because the definition of vulnerable persons in the officer response procedure standard contemplates youth, the definition provides that a person may be vulnerable based on, among other things, age or developmental maturity. It struck us as more appropriate to instruct officers to treat all youth, including youth with disabilities, as vulnerable persons. And so because the sub-policy or provision concerning interactions with vulnerable persons directs officers to utilize developmentally and age-appropriate, trauma-informed, racially equitable, culturally relevant tactics and techniques, which is what was included in prior draft, we remove that here because now it's incorporated by reference. The second revision to officer conduct seeks to direct officers to take the least intrusive action that is effective under the circumstances in light of factors that are unique to youth in terms of their behavior as well as their susceptibility to law enforcement action. And so the original draft, as you'll see on the left side of your screen, directed officers to consider whether a law enforcement response is appropriate when engaging with a youth. We heard from MPTC during their August meeting that officers must always respond to a call for service. So in their words, officers didn't really have the ability to consider whether a law enforcement response is appropriate. They have to go out. That, in their view, is a law enforcement response. And so, we thought about this and we realized, the intent here, the original intent was to guide officers when determining what to do when responding to a call for service or after responding to a call for service, rather than whether to respond to that call at all. And so to address this, we've essentially combined what was 3 and 4, which is what you see on the left side of your screen, into just one directive, so that officers are guided when determining what action to take after or when responding, to take the least intrusive action that is effective in light of factors that are particular to or may affect you. The second revised element to this standard is a new element. I'll note that it is new to this specific standard, but not new to agency certification as a whole. I'll briefly explain that more in a second. And it concerns investigatory stops of youth. Strategies for Youth suggested that based on age and developmental maturity differences, the Juvenile Operations standard would benefit from a provision explicitly addressing the investigatory stops of youth. Because the draft criminal investigation procedure standards already substantively addresses general standards and procedures that must be met and followed when conducting investigatory stops, such as having reasonable suspicion, for a stop, limiting the scope of a stop to confirming or dispelling that reasonable suspicion, this proposed section seeks to first incorporate what's already required in the criminal investigation standard by reference. So that's the first part that you'll see on your screen here. The second is to encourage officers to consider that certain behavioral responses by a youth may be a result of their age or lack of developmental maturity, and therefore not necessarily indicative of criminal activity, such as fleeing, freezing, verbally challenging an officer. Other examples are on your screen. And the third piece is to direct and encourage officers to engage in certain conduct before commencing a consent search of a youth, which includes directing officers to commence a consent search only after obtaining the youth's clear and unambiguous consent to the search, and encouraging officers to explain to the youth their rights with respect to a consent search, that a youth is free to refuse, limit, or revoke consent to a search at any time. And so the second and third pieces were not included in the criminal investigation procedure standard, which is why they're enumerated here. And these are things that we feel are specific to youth. The next revised element concerns arrest. This proposed revision is to direct officers to, when executing arrests of youth, to act in accordance with bias-free policing principles and the agency's code of conduct. This is based on another comment provided by Strategies for Youth, which highlighted a finding by the Massachusetts Juvenile Justice Policy and Data Board in its March 2025 report. That finding detailed significant disparities in arrests and youthful offender complaints against Black and Latinx youth. As Strategies for Youth suggested that in light of this finding, it would be beneficial to address race, national origin, and ethnic disparities in interactions with youth. The next revised element concerns the temporary custody of youth on agency premises. When MPTC reviewed this piece, they raised concerns about the feasibility of keeping a youth under constant and direct supervision. To address those concerns, we suggested revising constant to be regular and clarifying that supervision may be accomplished by either direct observation or through live and/or video transmission. The next revised element concerns the transportation of youths, and I'll specify here that it's the transportation of youths who are not detainees. Transportation of youths who are detainees is covered in a detainee transportation standard, which was before you last month. MPTC noted that as originally drafted, this specific provision would prevent officers from transporting a youth with their adult parent. And so to address this, we revised this section so there's a limited exception to the general prohibition on transporting youth and adults. As revised, officers may transport a youth with an adult, provided that the adult is a youth's parent, legal guardian, or responsible adult. The next revised element concerns the policing of youth caregivers. The initial draft included 2 sub-policies or provisions concerning youths who are collaterally impacted by the policing of their caregivers, specifically in the context of the arrest of a youth's caregivers and the execution of a residential search warrant of a youth's caregiver. Within those 2 sub-policies and provisions, again, as initially drafted, we called on officers to take certain actions, like attempting to conduct those activities out of sight and sound from any youth and working with DCF to identify alternative caregivers if necessary. And so to simplify here, we've just combined those 2 sub-policies or provisions into a general sub-policy or provision concerning youth affected by law enforcement activities that target their caregivers, including the arrest of a caregiver, provision of an emergency medical response to a caregiver, or execution of a search warrant. And we list the various actions that officers should take. And again, those actions are consistent with what was originally presented to you. Based on a suggestion by the juvenile court, though, we also propose adding to that list of actions. And that specific proposal by the juvenile court was to say that officers should be directed to file a 51A report, that is a report of suspected child abuse or neglect, with DCF if circumstances require. The next element is a new one, and it concerns assistance or support to the Department of Children and Families. So the initial draft sought to direct officers to follow certain standards and procedures when serving notices of petitions for termination of parental rights and notices of and removing youths from their homes due to suspected abuse or neglect. The MPTC, however, noted that these efforts are the responsibility of DCF and that when officers are involved, they're involved in merely an assistive or supportive role. And so in order to adjust to that, we have revised this provision so that rather than setting specific directives for officers in those scenarios, the agencies are directed to develop a sub-policy or provision that addresses the role of officers, the responsibilities officers have, and the limitations upon officers when supporting or assisting DCF in such matters. The next element concerns immigration enforcement. We received just general feedback that this provision would benefit from more elaboration. However, I think because there's so much happening in this arena that's hyper-local, and a lot of different municipalities are setting different directives or different limitations upon local law enforcement's involvement in federal immigration matters, what we've done here is just try to remind agencies of the different guideposts by which they should be acting, and that includes the preliminarily approved standard regarding officer response procedures, which contains a sub-policy or provision specific to involvement in immigration enforcement efforts, general bias-free policing principles, as well as the agency's code of conduct policy. The next revised element concerns congregate care placement sites. When we met with the juvenile court, they suggested that because there's a spectrum of congregate care placement sites, some sites serve youths with high support needs and others serve youths with lower support needs, agencies would benefit from being trained by those specific congregate care placement sites on how to respond to those specific sites, because each site serves a specific kind of population with different needs. And so what we've done here is try to encourage agencies to work with the congregate care placement sites in their jurisdiction on developing and providing training to the agencies and their officers on how to respond to youth at those specific sites. The next element is a new one concerning child requiring assistance matters. This is also a product of our conversation with the juvenile court. The juvenile court indicated that it often receives questions on what officers can and can't do when responding to a call for service that involves a youth who is the subject of a CRA case. And so they suggested it would be helpful for the juvenile operations standard to include a sub-policy or provision that sort of outlines what officers can do and cannot do, what their role is when responding to a youth who is a subject of a CRA case. And that's very much done in the same style as the sub-policy or provision that was before you about providing assistance or support to DCF. The final element of juvenile operations today is also a new element concerning relationships with youth. The revised draft, at the suggestion of Commission staff and Strategies for Youth, seeks to more broadly address relationships between officers and youth. So to that, we initially prohibited officers from engaging in sexual relationships with youth in accordance with applicable law. Here we've expanded that to prohibit officers from first engaging in sexual conduct with youth if they feel that that might fall short of a sexual relationship. Second, from sexually harassing youth. And third, engaging in dating and romantic relationships with youth that officers encounter in the course of executing official duties. We also seek to address communications with youth outside any official duties. And so at a minimum here, we propose that in figuring out sort of the do's and don'ts with communicating with youth outside of official duties, we say at a minimum, officers should be prohibited from disseminating or soliciting from youth content of a sexual nature. And so in short, we prohibit sexting with youth in accordance with applicable law. Second, addressing when it is and is not okay to have unmonitored, private, and direct communications with a youth. And third, addressing when it is and is not okay to communicate over the phone or internet with a youth. And the reason that we include this here, I have to say, is not because we think that officers or even the majority of officers are engaging in this behavior with youth, but because this has been a recurring pattern or theme that has come up in some of the cases that you have heard before you in executive session from the Division of Standards. We felt strongly that this is something that should be addressed in agency certification. And so that concludes my presentation on juvenile operations. I'll stop sharing my screen to take any questions or reactions you may have. Commissioner Luma?
One, just thank you for the presentation. Thought it was a really good presentation. I just have questions about the responsibilities of these agencies to create these sub-policies, specifically around DCF matters and the CRAs. Do we provide any support, technical assistance around that, or draft policies for them?
We haven't, I believe, authored anything in those specific topics, though I believe there are other agencies and partners who are engaged in that area. So we can certainly sort of point to different resources that may help agencies in drafting those sub-policies or provisions.
Well, one of the things I appreciate about these policies is that it allows for consistency across all agencies. And I think some of that will be lost if we're asking or requesting each agency to develop their own sub-policies. So even if there were just guideline considerations and how we're thinking about these specific, especially because they're involving juveniles, I think it'd be helpful.
Yes, we can thank you, Commissioner Luma. We can certainly sort of try to provide more guidelines or point to other resources that provide those guidelines. Commissioner Crispin?
Yes, good morning. Thank you for the presentation. Just had some questions around removals and precepts. I know oftentimes officers are asked to step into these situations and remove children who the parents may not be willing to let go of, or take issue with whatever DCF has decided, the courts have decided. I think it's important that we do more than just have DCF draft regulations around what the officers' roles are. I think it's a tough position for officers to be in when you're asked to step into these situations, potentially be physical with removing children from homes. So I think if there is going to be some guideline, there'd be some guideline that comes from us or MPTC, so that officers have a better sense as to what they can do and what they shouldn't be doing, right? Because I think from a perception, I think people are going to see officers stepping into these roles, and there may be some level of force used to remove these children. It's a compromising situation for police officers. So I think we need to do more than just have DCF draft guidelines. If there is going to be guidelines, they come either from the courts or from us directly or PTC.
Okay, yes, we can certainly try to make this more specific.
Any other questions or comments? Let me echo Commissioner Luma and Commissioner Crispin's thanks, Attorney Lee, for your presentation and for your outreach efforts. Certainly, the input that you've had from the Juvenile Court Administration and from Strategies for Youth has been very helpful in reframing the information that you provided to us. And again, the commissioners reiterate our gratitude to you for your outreach to the concerned groups that are impacted by the information that you've been working with. Thank you very much. And moving on now to collection and preservation of evidence.
Thank you. Let me just resharing my screen. Here we go. So the last standard for today is collection and preservation of evidence. A copy of this draft is in your packet starting at page 119. As I mentioned, this is the first time the standard is before you, so we're just looking for initial feedback and reactions here. And so with this standard, as with every other standard, we consulted a variety of resources, including but not limited to those which are listed on the left side of your screen. These materials represent best practices from government working groups, as well as law enforcement interest groups, implemented policies from agencies both in the Commonwealth and outside the Commonwealth, independent reports of certain agencies in the Commonwealth, as well as statutes and regulations already in effect in the Commonwealth. And so those resources identified 12 topics as key elements for inclusion in a potential collection and preservation of evidence standard, which are listed on the right side of your screen and which I'll walk you through. The first is, as with every standard, key principles. Because evidence may be used in significant ways in a criminal prosecution that may have significant repercussions on an individual and a defendant's rights and liberties, an agency's collection and preservation of evidence policies should ensure compliance with the Constitution. The second element here is on specific types of evidence. The draft standard directs agencies to set forth requirements and or restrictions for the collection and preservation of specific types of evidence that officers may reasonably encounter, such as biological evidence, weapons and firearms, cash, documents, and digital evidence. This is a non-exhaustive list. You'll see a much longer list in the draft standard. For each type of evidence, we ask that agencies should address whether it's appropriate for an officer to collect that evidence or whether that piece of evidence requires collection by specialized personnel. In the event of the latter, it requires specialized personnel. We ask agencies to outline procedures for officers to request that specialized personnel. From there, agencies should also address the tasks officers should perform when either collecting a piece of evidence or waiting for specialized personnel to arrive. The next element pertains to initial collection and preservation. The draft standard here directs agencies to address the collection and preservation of evidence in common scenarios, including at the scene of an alleged or possible crime, under exigent circumstances, pursuant to a consent search, pursuant to a search warrant, and when working with other law enforcement bodies and governmental entities, such as the state police. Next, it directs agencies to set forth best practices concerning equipment that may be used to collect and preserve evidence, as well as requirements for the packaging and labeling of evidence. And finally, to ensure that collective evidence is accounted for and later able to be processed, the draft standard requires that agencies direct officers to maintain any collected evidence until that evidence is transferred or secured in storage. Which leads me to the next element on transportation and transfer. To ensure that evidence is handled appropriately beyond initial collection and preservation, agencies should also address the transportation and transfer of evidence. And so with respect to transportation, we believe that agencies should first direct that evidence be transported with undue delay. Second, set requirements for the maintenance of the security and chain of custody of any evidence being transported and the prevention of any cross-contamination of any transported evidence. And third, set procedures for the accounting of any evidence being transported. So what started at point A is also available at point B. On transfer, the provisions regarding the transfer of evidence should address scenarios in which evidence may be transferred, including in the field, internally, temporarily, and permanently. The next element concerns storage. Because it may take months and even years for a trial to come to fruition, it is crucial that agencies store and preserve evidence in a way that maintains its integrity so it can be used at any point after initial collection, including at a trial. To that end, the draft standard directs agencies to develop and implement a sub-policy or provision concerning the storage and preservation of evidence that sets requirements and restrictions concerning first, where evidence may be stored. Second, how evidence may be stored, meaning the packaging and labeling. Third, short and long-term storage. Fourth, security measures and protocols for any spaces in which evidence is stored. Fifth, the routine inspection of any spaces in which evidence is stored. And finally, the inventorying and accounting of stored evidence. We also suggest that agencies should address the submission of evidence to a forensic laboratory. It's fairly self-explanatory here. This is in accordance with any applicable laws and regulations, including those that have already been promulgated by the state police, because I understand the state police crime lab does a lot of this processing for agencies. This sub-policy or provision is aimed at ensuring that evidence is processed and analyzed if needed. The next element relates to retention. In compliance with Massachusetts laws regarding post-conviction rights, as well as sexual assault reporting and prosecuting, the draft standard requires agencies to develop a policy or provision concerning the retention of evidence that complies with those existing laws. The next piece concerns relinquishment, permanent release, and disposal. While agencies are expected to store and retain evidence, it would be overly burdensome and impractical for agencies to store and retain evidence indefinitely, especially in cases where a trial has come and gone or post-conviction rights are not applicable. And so therefore, agencies need some way to relinquish, permanently release, and dispose of evidence to ensure that that happens in compliance with applicable law, including those retention laws. Agencies should address first the circumstances under which it is okay or not okay to relinquish, permanently release, or dispose of evidence. Second, they should set requirements concerning any required notification and authorization prior to relinquishing, permanently releasing, or disposing of evidence. That could be in coordination with a DA's office or with the state police or any other agencies in which there's a coordinated investigation. Third, it should also set forth requirements concerning the documentation of the relinquishment, permanent release, and disposal. And fourth, it should also set requirements concerning the relinquishment, permanent release, and disposal of evidence of a sensitive nature. And so by sensitive nature, we generally here mean biological evidence, firearms, drugs, narcotics, unidentified substances, biohazards, things of that nature. The next element is chain of custody. A lot of what has been described before already is about maintaining the chain of custody for any evidence collected and preserved by the agency, because the chain of custody, and specifically a well-maintained and documented one, is essential to ensuring the legal integrity and authenticity of evidence when used in a criminal trial. Therefore, an agency should have a sub-policy or provision concerning the maintenance of the chain of custody that should set forth requirements concerning, first, who is responsible for entering information into and updating a chain of custody log. Second, what is required to be recorded in that chain of custody log. And then third, when the chain of custody log is required to be updated. And so that way you can track a piece of evidence from initial collection all the way through the different ways that it's been used or being stored up until its final usage or relinquishment, permanent release, or disposal. The next piece is a tracking system. This is distinct from the chain of custody. This is to ensure that officers and others are able to access and use evidence as necessary. And so therefore, agencies should have an evidence tracking system that allows the agency to first search for a particular piece of evidence and second, identify where that evidence is, including the specific location within the agency. Our second to last element is internal auditing. And this is to ensure compliance and accountability with the agency's collection and preservation of evidence policy and practices. To that end, agencies should develop and implement internal auditing sub-policy or provision that sets requirements for the auditing of any evidence that the agency is storing, any evidence that the agency is retaining, the records of officers and personnel who have access to stored evidence, as well as the chain of custody log. And as usual, our last element is training. To ensure adherence to this policy, agencies should ensure that all officers are trained in the collection and preservation of evidence in accordance with all applicable requirements, including those set by the MPTC. That concludes my presentation on collection and preservation of evidence. Happy to answer any questions or take any reactions. Commissioner Luna? Yeah, sorry.
Thank you again for your presentation. It's very helpful. One of the things, and I don't know what the current standard is, or if it's already being addressed, but I know one of the challenges that I've experienced from being in this office is that oftentimes there are challenges with victims accessing their belongings or evidence post disposition. Victims or survivors, so I'm not sure if that's considered. I know we talked about for the preservation of evidence during trial, but I also think about the belongings of victims and survivors and them wanting access to that, or their family members wanting access to their belongings. So I don't know if there's some provision or something that can mention the importance of labeling who the items actually belong to so they can be accessible afterwards. You've had situations where that it just couldn't be found, particularly with homicide survivors. They want the belongings of their loved ones, and we can't even provide that to them as a form of closure. So I just want that to be considered as we're thinking about the importance of not only logging and tracking for trial, but also those who've been directly impacted by crimes.
Absolutely, we can do that.
Any other questions or comments from the commissioners? Attorney Lee, let me thank you for the extraordinarily comprehensive presentation that you provided to us today. I think it certainly leaves the commissioners with a lot to think about, and we are grateful to you for that. And I think with that, is there anything else, General Counsel, that we're going to address from a legal perspective in our public meeting today?
No, thank you.
Thank you. And there are no matters which were not anticipated by me at the time of posting. So at this point, I would entertain a motion to go into executive session in accordance with General Laws, Chapter 38, Sections 21A1, to discuss the discipline or the dismissal of or complaints or charges brought against a public officer, employee, or individual under the same statute, Section 21A5, to discuss the investigation of charges of criminal misconduct under the same statute, Section 21A7, combined with General Laws, Chapter 60, Section 8C2, and to the extent they may be applicable, General Laws, Chapter 6, Sections 168 and 178, and General Laws, Chapter 119, Section 5E, to discuss matters relating to preliminary inquiries and initial staff review concerning whether to initiate such inquiries and regarding certain criminal or juvenile record information and the reporting of suspected child abuse or neglect, and General Laws, again, Chapter 38, Section 21A7, combined with Sections 22F and G of the same statute, to discuss and to approve prior executive session minutes. We will be addressing reports of preliminary inquiry in 5 cases. We will be addressing Division of Standards request to enter voluntary decertification, suspension, or disposition agreement in 5 cases. I'm sorry, that is, I think, in 4 cases. And we will be addressing Division of Standards requests for approval to conduct preliminary inquiries in 7 cases. Is there a motion to go into executive session?
Yes, so moved.
Is there a second?
Second.
Thank you. Commissioner Bluestone, please.
Yes.
Commissioner Calderon,
Yes.
Commissioner Crispin,
Yes.
Commissioner Hall,
Yes.
Commissioner Kasrosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Tally,
Yes.
and I'm also a yes. And I think with that, members of the public, we will not be returning to the public meeting after the executive session. Thank you very much for participating today in our meeting. Thank every members of the commission staff who have worked on the materials that we've been provided with. Enrique, would you mind letting the members of the public know if they have any questions or comments, how they can communicate with the commission?
Yes, thank you, Madam Chair. The usual way, just go to our website, mapostcommission.gov, and all our information is there. We especially appreciate written comments. We distribute them as needed.
Thank you very much. Commissioners, we'll take a 5-minute break before we go into executive session. And I think, Jamie, thank you so much for always, as ever, organizing things. You have provided us with the update on how to get into the executive session, correct?
From Penny, yes.
Thank you so much. Goodbye for now.